Today's workshop is Navigating Dispute Resolution in Special Education. Today, I am joined by my co-presenter, Cammie Naylor, who is a staff attorney with the Disability Law Project at Vermont Legal Aid. As a former children's therapist, Cammie has long advocated for the needs of children and their families. She joined Vermont Legal Aid as a staff attorney in 2017. She has a deep passion for protecting the rights of children and advocating within spaces where children's needs and rights intersect. Cammie advocates for children with disabilities regarding their rights in schools and other individuals with disabilities who are facing legal problems like guardianship, access to health care, or discrimination because of their disabilities. Thank you so much for joining us today.
I am just going to share my presentation. Good morning. Thank you all so much for being here with us today. As Karen said, my name's Cammie Naylor. I'm a staff attorney with the Disability Law Project at Vermont Legal Aid. We're here today to talk about dispute resolution in special education. As an important, and thank you to VFN for graciously hosting this webinar today and providing the opportunity to offer information, insights, and strategies around resolving special education disputes. As an important disclaimer, the information provided during this presentation is for informational and educational purposes only and does not constitute legal advice. If you feel like you need legal advice, I strongly encourage you can reach out to our intake, and if you have questions about navigating the system, you should consider reaching out to us or VFN. They're an absolutely incredible resource. So as we get started, I want to share with you some of the objectives or learning objectives for today. So first, I hope that participants will learn about informal and formal dispute resolution. Participants will have tools to decide what advocacy strategy addresses their needs, and will develop initial tools for engaging in dispute resolution. Of course, the goal today is some tool development and giving you support around thinking through which advocacy strategies make the most sense for you in your situation. While we will offer tips and strategies, it's also important to acknowledge that even in my practice, I continue to learn new advocacy skills. I hope the discussion today can offer a where you might start and what you can expect foundation. We will do this by addressing some frequently asked questions that VFN compiled based on their recent experiences supporting families. But first, I'm going to provide you with a brief overview of dispute resolution opportunities. I've divided our dispute resolution opportunities into informal and formal dispute resolution. The IEP process itself, under the Individuals with Disabilities Education Act, provides a strong process for navigating disputes and for asking for things that you as a parent want to see in your child's IEP. Informally, you can request changes to the IEP, your child's individualized education program. You are a required IEP team member, so participation. Having and bringing up those hard discussions, it's hard, but it's worth it. And then making sure that you're asking for decisions in writing, whether it's a favorable decision, something that you agree with, or an unfavorable decision. An ounce of prevention. Sorry, I have a kiddo home with me today from a snow day. An ounce of prevention can be very helpful in the future if there is a dispute. In terms of formal dispute resolution, there are 3 major formal dispute resolution opportunities that are specifically identified and exist in the rules in the state and the federal special education rules. First is mediation. That's a process where a neutral third party helps facilitate solving problems. This can be done via asking for something specific, but it can also be a supported space to solve conflict. So this can be both an opportunity to develop a contract with a school and say, these are the things that you're going to do.
Mom, it's snowing.
Thank you. These are the things that you're going to do. These are the things that you're agreeing to, and this is what I'm agreeing to in the context of this also. But it can also be an opportunity to have a facilitated conversation to talk about, look, trust is lost. There needs to be a way to rebuild it. What are the issues and what are the barriers? And having a third party navigate through that. And mediation can also be some of both. And then we have the administrative complaint process. This is a federally required process that the state provides through the Agency of Education. The Agency of Education it's typically an attorney in partnership with an educator or someone with an education background. They investigate violations of the IDEA and state special education rules or the implementing regulations. Complaints must be filed within 1 year of an alleged violation. And then we have due process. This is a very formal evidentiary administrative hearing process. There's a 2-year statute of limitations from the date of a violation or the date that you became aware of an alleged violation. So there is some space if there is a circumstance where you learn about something that impacted a child's education and their educational access years after it has happened, there is that opportunity to say, I couldn't have known of this violation until this date because of this information. That doesn't include things like something that clearly happened in the educational record. It's more a former teacher pulls you aside and says, I really think you need to know that this happened to your child this school year. And there's nothing in that record. So that is just a brief overview of informal and formal dispute resolution opportunities. And we're gonna head straight into the frequently asked questions.
Okay, Cammie, these are questions that we put together at VFN based on our interactions with families who call our helpline. So, what do I do if my child needs services and the school isn't providing those services?
It's a simple but complicated answer. You have to ask for what you think your child needs. But I have a couple steps that I'd like to talk about developing that request and how to go about making a request and things that you should know. So if there is a service that a parent believes should be in their child's IEP that their child isn't receiving, you first want to look at what evidence do you have that my child needs this service? So asking yourself, when was my child's last evaluation? Does that evaluation address a need for this service or support what I want? If not, do I have other data or sources to support my request? Perhaps a physician or a therapist or a clinical provider. Is there evidence for the thing I want? Is the thing I want something the school needs to provide? And a good example of this is in the world of related services. So related services are services that schools have to provide in order to enable a child to access their education. That's kind of a tricky concept sometimes. So let's take the specific example of transportation. If you feel like individualized transportation would be helpful to your child or to your family, that is likely not a good reason to request transportation as a related service. If accessing the current transportation or the bus system is a barrier to your child getting to school, either because of behavior or something related to their disability, like the bus isn't accessible, then that is a very good reason to ask for transportation as a related service. So there's a very strong distinction between what would be helpful and what is necessary for a child to access their education. Another example of this is counseling services. Many people can benefit from counseling services. Certainly, there are children with disabilities who will benefit from counseling services. Whether counseling services should be provided as a related service in an IEP has to do with the analysis of, is this necessary for this child to access their education versus is this the service that's kind of offered and available to all kids? And then there's the added complexity of the fact that because related services specifically, the district only needs to provide so much that a child can access their education. Commonly, the amount of counseling service a child is offered in an IEP is not the amount of counseling services they might need to make progress on the reasons that they need counseling. It's what the IEP team has decided is enough so that the child can get some of the support that they need, learn some strategies, and be able to access their education. So those are some of the things you want to think about in developing an ask. What's my evidence? What is it that I want? Really understanding what you want. How am I going to show that I want this? And is this something the school has to provide? And then moving on from there, there's some things you need to know. Pursuant to Rule 2363.4E, a parent can ask at any time for a change in their IEP, or in their child's IEP, excuse me. When the parent asks for a change, the LEA, the local education agency, must do one of three things: convene an IEP meeting within 30 days, refuse and provide written notice, and notify parents of their right to initiate a hearing if they disagree with that decision. So items 2 and 3 are very inextricably linked. And that notice is Form 7. It's the specialized form from the Agency of Education's website. So something like an email back saying, hey, we're not doing this is not sufficient. So if you make a request for a change to your child's IEP, you should expect that you're either going to get a written explanation or an IEP meeting is scheduled. If you don't get either, something didn't go right. It's important. It's really challenging and really frustrating, but it is really important to note how IEP teams make decisions and who gets to ultimately make decisions on IEP teams. So parents are members of IEP teams. Parents are supposed to be at all IEP teams, except in exceptional circumstances, and as a member, provide input. However, IEP teams make decisions based on consensus. What that consensus means is not a parent necessarily agrees. Consensus really is everybody who's sitting at the table can say, okay, this is good enough. If an IEP team can't reach consensus, it is the LEA's responsibility to decide the contents of an IEP and provide parents that prior written notice, that Form 7, as well as notice of their dispute resolution rights. So we had a very early question that asked, what can parents do to change their child's IEP? The answer is you can make the ask, you can follow the IEP process. You may still not get what you want. If you don't get what you want, you are entitled to that Form 7. And then you would use that Form 7 to consider what are the next steps. Do I want to ask for mediation? Am I going to file an administrative complaint? Is this so severe that I think I might need to file for due process?
So Cammie,
Yes.
I'll just ask you any clarifying questions, and for everyone else, I'll save the substantive questions till the end. So there was a question about which rule number. Can you please give the number of that rule again, please?
The rule regarding what happens if a parent makes a request.
Yeah.
Okay.
Is that it? Yeah, I'm not sure when exactly that came in. Certainly the
Okay.
person who asked can unmute themselves,
Okay.
but
So the rule that tells schools what they should do when a parent makes a request for a change to their child's IEP team, or excuse me, IEP, is Rule 2363.4E. So that's the contents of the IEP rule, and it's the last subsection of that rule. The rule that explains IEP team decision making and explains that if the IEP team can't reach consensus, it's the LEA's responsibility to make and issue a decision. That's Rule 2363.3D. So 2363.3D. And these are the rules that I'm referencing are the rules from the Vermont Special Education Rules approved by our Vermont State Board of Education and implemented in regulation in Vermont.
okay, so the note says, because I was going back and forth, the rule regarding having an IEP meeting within 30 days.
Yeah,
Okay.
2363.4E. Okay, and then we have some strategies for things that you should do in the context of, if I can get my cursor back, in the context of having made a request. So the first is you have to make your request clearly and in writing. You should clearly state what it is you want, what you want addressed. If you're making a request for a change to the IEP, you can also affirmatively ask that a meeting is scheduled within 30 days. Let the school know that you know they have to hold a meeting within 30 days. And you can ask that there's an appropriate person at the meeting with the authority to make a decision. Once you've had a meeting, you've had the discussion, whether the team is going to agree or not, I recommend that you ask at the end of the meeting for whomever took minutes to provide you a copy of the minutes as soon as possible. The minutes you should get those minutes and you should review them. The minutes should clearly explain the discussion that was had at the IEP team meeting. And you should make sure that the minutes reflect your understanding of that conversation. If there is something in the minutes that does not reflect what you recall or what your experience in the IEP team meeting was, you should consider writing an email or a letter to your child's special education case manager explaining what your understanding of the meeting minutes, how your understanding of the meeting is different than what's reflected in the minutes, and asking that that be included as an addendum to the IEP team meeting minutes for that particular meeting. There are other things that you can do to try to change minutes, but that is a really good, straightforward strategy to make sure that there's the official minutes and that your comments and your reflection, your recollection of that meeting is included together with those minutes. In terms of being at the IEP team meeting, parents can bring a support person. Parents are encouraged to bring support people. Bringing someone to support you at your child's IEP meeting can be really helpful in terms of helping you recall all of the conversation that was had in a very stressful situation, or freeing you up so that you're not thinking both about participating in the meeting and making your own notes about what occurred. And then, of course, whether the team agrees with your request or not, making sure that you get that written explanation of prior written notice. That prior written notice is that Form 7 I was describing earlier. That form includes a description that the school has to provide of the action that's going to be taken, a description of what that action is, the basis for that decision or change, any other considerations that were made or dismissed, and other factors. If you disagree with what the team has decided, but you decide that you don't want to pursue another dispute resolution strategy related to that refusal to provide what you want, there's the parent input form that should be provided to you with any IEP amendments. And the parent input form is required in the Vermont rules by Rule 2363.7J. And that should be included in your child's file together with that IEP that was amended. Schools are required to provide you the parent input form. It is a parent's choice to send that back. If you send it back and you disagree, it's the school's decision whether they decide to schedule a follow-up meeting. They don't have to schedule a follow-up meeting even if you disagree and you've put that in the parental form. And so if you disagree, you've had a meeting, you've made a request, you've had a meeting, you disagree with the decision, you get an explanation of that decision and the parent input form. You put your opinion in the parent input form and you send it back to the school. If you want another meeting to discuss this issue, you should be affirmatively requesting that, because this is important documentation to reflect that you don't fully agree with the IEP, but it does not require the school to take any action. It's an optional that they would schedule a follow-up meeting. So those are, and in general, I recommend to parents to keep good records. Keep copies or digitize them and keep them in a particular location. One of the reasons that it's so important to provide that parental input form, it is very common for me to be getting a phone call from a parent saying the school is doing this and I disagree with this service. I don't think it's good enough. This is why it's not good enough. And we discuss the circumstances. And then I say, okay, well, I really need to review the records. I review the records and there is no notification or notice that the parent never really agreed with that decision. And from a legal perspective, not registering your dissent is the equivalent of assenting or agreeing. So it's really important to continue to provide that feedback and to continue to ask for changes. Karen, do you have anything to add to?
I just wanted to make note of when you were talking about related services, that one that is often overlooked with parents is the parent training and counseling related service. So that can be a related service put in your child's IEP if it can be backed up.
Thanks, Karen. All right. Next question.
Okay, next question. What are my options if I think a service provider is not qualified?
Your options are limited. It's essential. The essential question is the provider I'm concerned about qualified? And a pretty straightforward answer is, do they have the qualifications identified on the IEP service page? So if your child is supposed to be getting speech language services from a speech language pathologist, and they're getting those services from an SLPA, that provider may not be qualified to provide that service your child's entitled to. In the world of staffing shortages, something is certainly better than nothing. But in general, districts are required to hire staff who have the prerequisite qualifications to fill a position. If a person was hired by the district, it's a general consideration that they have the qualifications necessary to fill that role. And from a legal perspective, that is commonly how a hearing officer would look at that. If the district hired this person, they're qualified. The question of is someone in the school district qualified is a different question than is this the right person to be supporting my child? Districts have, well settled in law, the exclusive right to make staffing determinations unless an IEP specifies that a particular person or a particular set of qualifications that a person would have is necessary to provide the service. If you have concerns about whether a provider who's working with your child is qualified, the AOE does have a licensing lookup, and you can look up an educator's license. There are a couple circumstances where someone might not show up. Someone who has a license that's in process. I've certainly had the experience of trying to look someone up and not being able to find them because the name that they go by is not their given legal name. And so I was unable to find them in the lookup system until I knew their full name. And then there's a couple of providers who would be regulated through the OPR, the Office of Professional Regulation, and not the Agency of Education. And those would commonly be your related service providers. Although one caveat to that is SLPs can be licensed through education and can also be licensed professionally. So there are a couple different places where you can go to try to do your homework to see if someone is licensed, is qualified, but it's not a perfect solution. Anything to add, Karen?
I've just put the link to that page in the chat, and just a quick time check. We're about halfway through, Cammie. So, thank you.
Okay. So here's our next question.
Yes, which dispute resolution path is correct for my situation?
This is really hard. I think it takes asking yourself some questions in advance. What's the issue? What's my goal? What steps have I taken? What evidence do I have? What is the impact of this thing I disagree with? And one other thing that's not on here, I think is really important is what's the quality of my relationship with the school? So here are some places where you might have a particular goal, and I'm just going to talk about what I would recommend or what I would be thinking about. So if you want to see a change to your child's IEP, I would start with informal. I would make that request and have the meeting. If you want to address a problem, something's ongoing, your child's not being served, or something's standing in the way of theirs being served, in general, I think an IEP meeting is the right place to start. However, if your child's experiencing interactions that are not confined to the IDEA, things like teasing, harassment, or bullying, I would, again, first try to address that problem with starting directly with the school. But the administrative complaint process is only available to investigate allegations of failures under the IDEA, Part B of the IDEA. And so if your child is experiencing hazing, harassment, or bullying at school, an admin complaint option to raise those concerns is not going to be an option that gets you what you want or need. So other options in that circumstance would be asking the school if they would go to mediation. Can we go and discuss and develop a strategy here? Alternatively, if there's an HHB circumstance, there are other provisions in hazing, harassment, and bullying rules involving independent investigations or board hearings. And so if you're looking to address a problem, change something, and that's not been changed and now it's a problem and you're looking to address it, if the IEP meeting, team meeting isn't working, you can file an administrative complaint. and say, you know, this is what's denying my child a free and appropriate public education. When you file an administrative complaint, you are commonly offered mediation also. So you file the admin complaint, there's a checkbox in the admin complaint that says, yes, I'm interested in mediation. I tend to encourage folks to go to mediation. The reason that I encourage folks to go to mediation, if that is an option, is multifaceted. One, it is an opportunity to have frank conversations outside the context and procedures of the IEP team. Sometimes there are rules that limit the IEP team from agreeing to what a parent is asking for, even if the school fundamentally agrees. And so going to mediation can be really powerful because it allows a parent and a representative of the school district to make decisions about what might go into the child's IEP outside the context of the IEP team. So it is, if you are thinking about going to mediation or filing an administrative complaint, it is really important to ask for what you want, to know what it is you want, what is your goal, and have that pretty well stated. If you believe that your child has been denied services and hasn't been receiving FAPE and isn't getting what they need, and you want to go to mediation, it's a really good idea to sit down with yourself and say, what are the things that I want? What are all the things I want for my child? What are the things that would be good to have? And what are the things that I must have to reach an agreement? Because mediation is inherently a negotiation. There is give and take. The school is going to be giving up something, and you are likely going to be giving up something as well. If there is an ongoing problem, denial of service, something like that, if you have good evidence that that is happening and you need to solve that problem, mediation can be an option. Administrative complaint can be an option. And if you have that good evidence, due process can also be an option. If you are in a circumstance where you feel like something is not going right, I don't think my child's getting what they need, but you're on the fence, or there's confusing factors, or you know that there's been discipline and that discipline was legitimate, but now is it overreaching? An administrative complaint can be a really good process to solve that because it's an investigation by the Agency of Education, and they will come in after an investigation period. If you don't reach an agreement through mediation with the school district, they will come in and they will say, we think this was a denial of free and appropriate public education. We think this was a denial of a child's right to a least restrictive environment. Or they will say, we have reviewed these circumstances. Here's our analysis of what has happened. And we don't think that there was a denial. And so that can be a way to confirm what you believe, or to say something doesn't feel right to me and I really want someone else's eyes on this. If you go through a whole administrative complaint process and you don't reach an agreement at mediation, the Agency of Education has 60 days to conduct their investigation, and they have to issue findings. And those findings are recommended actions to take. So they can order schools to do certain things, but they can't order schools to do other things. For example, if there has been a denial of FAPE, if an investigation finds there was a denial of FAPE, in general, the Agency of Education can order that an IEP meeting is convened to discuss what appropriate compensatory education is. They can't say, this is how much compensatory education is owed to this child. And so the benefit of finding yourself at mediation is that you really do get to have more control and autonomy in solving the problem. If you're looking to fix something, I would encourage considering, what is your evidence? What do you have? Due process might be an option, but also a more informal process, asking for an IEP team meeting, talking with the child's educators, talking with the LEA, even talking to a school board member. That can be really helpful. If you're looking to stop an action, from the school. So say something has gone on and you've gotten a prior written notice of decision that explains that these changes are going to be made to your child's educational program, and you disagree with those changes. You may need to consider filing due process to stop those changes from being implemented. So when you get that Form 7, you're supposed to receive that with reasonable notice before the changes are implemented. If it's something that's agreed to, commonly because it's agreed to and it's just a formal process, we'll make that effective day of. But if it's a big change, like one that I commonly see is, we think your child needs to go to an alternative program now, or we're taking all of these services away, and there's been many kids who have been put on tutorial placements in the last couple of years. If you want to try to stop or prevent a tutorial placement, you may need to file due process and invoke stay put, which occurs by function of law. So what that means is you would file for due process. You would say, I am filing for due process. I believe this proposed change denies my child a free and appropriate public education. Here are the reasons why. I am invoking stay put. When you invoke stay put, the school is then not allowed to implement the change that you disagree with. Your child reverts back to the educational placement that was last agreed upon by the IEP team. And I think here it's really important to note that placement is the entire package of services in the IEP. It's not just the physical location where a child's receiving their education. If you are so frustrated with your child's school and your district and things are terrible and you feel like you just need to litigate to feel justified. If your goal is to, and this is not an intentional goal and it's not a judgment, but if a goal that you have internally is to harass, delay, or needlessly litigate to tie the school up in some way, you should reassess. You should not file for due process. You might not even file an administrative complaint. Because if you file for due process and you follow that process and there is not a resolution and a hearing officer finds that you have engaged in that administrative hearing process and procedure to harass, delay, or needlessly litigate an issue that could have been solved, you could be on the hook for the school's legal legal expenses. So harass, delay, or needlessly litigate, you should reassess what you're doing. Otherwise, for any of these things that may be a goal, it's really a question of strategy. What is the outcome you want? How much autonomy do you want in that outcome? Is the quality of the relationship something that could be rebuilt? And is there a way to find your way back to a strong relationship? And I think ultimately it's really important to recognize that if you have a child who's in school, you are in a long-term relationship with your child's school, and you don't always have to agree, but for the sake of your child, it's incredibly important that you find ways and strategies to continue to work with the school. And that is commonly not easy. And I do not take that for granted. But if you can find ways to have functional relationships and make progress, then leveraging your informal strategies can be incredibly helpful. If there's a moment where there's an impasse or there's really, really clear, staunch disagreement, that might be an opportunity to leverage one of the more formal admin complaint, mediation, or due process. And there are certainly circumstances I found myself in where we need to leverage all of them. And it's just a matter of steps and elevating as necessary. So what is mediation? Mediation isn't one size fits all. Not every mediation I've been in has looked exactly the same. There is an impartial person. Mediation can happen in the same room or separate rooms where you're in a room by yourself or with a support person, and the district is in a different room, and your facilitator is going back and forth. Your mediator is going back and forth. Mediation can also happen at the same table with your mediator, creating space for asking questions and opportunities for districts to respond. Mediation is commonly virtual now. If you bring an attorney to mediation, the school district can bring an attorney. If you are not bringing an attorney, they cannot. It's been my experience that the Agency of Education and their contract mediators commonly schedule mediation for 4-hour blocks. Although it's also been my experience they're very open to extending that time frame if necessary. And mediation is confidential. You will sign a confidentiality agreement. If mediation is not successful, you cannot use anything that was discussed in the context of mediation in a future complaint against the school district. That what is said in mediation stays in mediation. However, if you reach a mediated agreement, that agreement becomes part of the your child's educational record. That agreement is also a contract that is enforceable in due process in the state court or in federal court. Administrative complaints. How do I file? What happens after I file? And what if the complaint doesn't solve the problem? Well, how do you file? I would search in your Google search bar, Vermont Agency of Education Administrative Complaint. That will bring you to the Agency of Education's mediation, due process, and administrative complaint website. About halfway down the page, there's a section on administrative complaints. There is a PDF that you can download and fill out, which is that admin complaint form, but they also have an online survey type form that you can fill out and submit right there in your web browser. When filing an administrative complaint, your complaint has to include a description of what you're alleging the violation is. So it has to include a statement of facts, a statement of what was violated, a statement of the associated facts, and a signature. Administrative complaints can be filed on behalf of an individual or a group of individuals. And for that concept of filing a group administrative complaint, that is commonly to address like a policy issue that's happening in a particular place. But for an individual complaint, that complaint also needs to include the name, age, address of the child, the school. If a child is homeless and protected under McKinney-Vento, their contact information. And again, a description of the problem and facts, as well as proposed resolution. Once you file an administrative complaint, you will commonly be offered mediation. Again, I encourage people to try mediation. The worst that happens if you try mediation is you don't reach an agreement and an investigation of your circumstances goes forward. If you file an administrative complaint, mediation is not successful, and you get a decision from the Agency of Education you disagree with, you could consider filing due process and trying to convince a hearing officer who's not bound by an administrative complaint decision to side with you. If corrective action that's found, like if you file an administrative complaint, the Agency of Education says, yes, your child's rights were violated, this is the recommended corrective action. If that corrective action is not carried out, in general, I encourage folks to inform the agency or refile. Commonly, administrative complaint cases remain open until the agency has determined satisfactory completion of corrective actions. again, administrative complaints are really powerful because you get that bite at mediation, but you also get that voice in suggesting a remedy. What would fix this problem? And a little bit more about due process. So we had some questions about due process. First, what's involved in filing for due process? Quite frankly, it's a lot. There are quick timelines. Lots of detail is required. There's lots of specific stages. The party requesting a hearing should submit a written complaint that includes a child's date of name, their date of birth, where they live, where the child is attending school, a description of the problem related to the proposed refused initiation or the child's identification, evaluation, or educational placement, and the facts relating to that problem, as well as a proposed resolution. So that's what's needed to initiate a due process hearing, to make that initial filing. Once you make that initial filing, timelines set into place, and there will be a scheduling order when you have an initial conference with your independent hearing officer that talks about when documents need to be exchanged and when there's a proposed statement of facts and when does a resolution session have to happen and when might mediation have to happen. And it is a very labor intensive process, and it's also a very, quite honestly, short process. So if you're filing for due process because there's a placement dispute, you might consider filing for expedited due process, which has a 45-day timeline. Otherwise, due process proceedings commonly have a 75-day timeline between the date of initiation and the date that a decision is due. So it is a very fast procedure. It's a very highly legal procedure, and it can be very technical. Do you need an attorney? Not necessarily. But if you are going to file for due process and you don't have an attorney, you should have a really strong understanding of what is required by just the rules of the due process procedure, a really good understanding of what your issues are, and you need to be very organized. And it is very hard for parents to file for and be successful at due process without the help of an attorney. Other than attorneys, who can help? Attorneys can help. Non-attorney advocates can also help in certain circumstances. There are some limitations on whether supporting in a due process hearing procedure is a legal practice, but non-attorney advocates are allowed to help based on the due process rules. And then we got the question, can the DLP help? So the DLP cannot help in cases where a parent has first filed and is then seeking our advice. We cannot give you any information in that case. There are times when we will consider representing in a due process proceeding. And we have a number of things that we look at and think about when we're trying to make a decision about whether we're going to offer legal service and what legal service we are going to offer. Whether a person has a disability that falls within a category that we receive funding for, whether that disability is related to their legal problems, whether the legal problems fall within our case acceptance priorities, which are dictated by our grantors, and then also whether that case has strong legal merit. So commonly, if someone is requesting service from us and they're requesting something that may be a high level of service, we have to conduct a merit review and we have to review the records before we can even be ready to make a service offer. And that can take some time. And then regardless of whether a case has merit, sometimes we have to make decisions based on whether we have the staff to to take a case, whether we have enough staff resources to give that case the care that it deserves. So yes, we can help with due process. We will help with due process, but we do not make those decisions lightly.
So Cammie, before I ask this next question, I can see we're running up with time. So a couple of questions. Are you able to stay for a little longer?
Yes.
Okay. Would you like to put a time on that? Say 10, 15? Or
I can stay until 11:20.
11? Okay, 11:20. That's what I meant. Okay, so and there are a lot of questions, so we will try to get
Okay.
through as many as we can.
Okay.
So with this next question, I feel like the school is retaliating against me for advocating for my child. What do I do?
The simple answer is to document well, keep good records, and continue to document in writing. But I think the question of retaliation is really challenging. Retaliation for advocating for a person with a disability is an ADA protected activity. Ultimately, it's my general opinion that people do not become educators to hurt kids or to hurt families. Um, there can be conflict between the role as a mandated reporter and what's required of that. I think I have certainly seen circumstances where, in carrying out what an educator perceives as their role as a mandated reporter, they have made an overzealous report. Um, Lots of schools also have different cultures. And so I think number one, protecting yourself and advocating for your child, the number one thing that you can do to ameliorate those concerns for retaliation is to have good relationships, and to continue to work with the schools, continue to talk to the schools. Clear communication is really important. If you believe that you have been retaliated against by someone on your child's IEP team or by an educator in your child's school, I would encourage you to first go to the school administration and report what has happened. If you don't get traction there, you can go to the district administration. And if you don't get traction there, you can go to the school board. But also, some conflict is good. And even if conflict is hard, or there's an eye roll or challenges in communication, it's worth continuing to persist in that conflict, because engaging in that good conflict commonly means a better outcome for your child. When communication breaks down, or when there is timelines involved, I do see sometimes the procedural requirements of the IDEA interfere with that relational aspect. And then there are check boxes or check marks in boxes for things that have to be done in a way that's not clearly communicated with families. And that can feel very retaliatory. Like, you just implemented this we didn't even do all these things. And I said that there was a problem. And it could be that. It also could be that there is an IEP regulated deadline and the district doesn't want to get dinked for being out of compliance. So in terms of how do you address a retaliation complaint, what do you do? How do I continue advocating for my child? I think fostering strong, respectful relationships is the first thing that you can do. Having good relationships with administrators, documenting in writing to keep yourself protected. If you believe that you've been actively discriminated against by the school for advocating for your child and saying something to the school principal or the LEA or a school board member isn't resolving that and it's still happening, you could consider filing a discrimination complaint, with the Agency of with the Vermont Human Rights Commission for that ADA protection. You could also consider filing an administrative complaint for a violation of your parental rights as a member and role of your child's IEP team with the Agency of Education. These are not actions against parents, are not cases the DLP would be able to support in. When we get cases, we have to represent the child with a disability. So if we do get a case and we do find that there's active retaliation happening, which has happened, we have seen, if there are other credible legal claims that we can make, we will include that retaliation in a complaint on behalf of the child, but we will not necessarily just be able to offer representing a parent. And I think there is a fear of engaging in formal dispute resolution. It's challenging and it can be seen as a barrier. I have certainly had experiences where it has been my perception that schools felt like their hands were tied based on whatever the circumstances were. And we're actually really grateful that we had filed a complaint or asked for mediation because we were opening up other avenues for other resources. And so I think as challenging as it can be, engaging in that good conflict and keeping good records is the best thing that you can do in advocating for your child and protecting yourself from retaliation. Karen, do you have anything to add?
Nope. So, Cammie, do you have any quick communication tips that will help avoid formal dispute resolution?
I don't think formal dispute resolution is something to avoid, quite frankly. I think it's a really important tool. And in fact, if you are at a point where you think formal dispute resolution might be the right solution, and you're choosing not to do that because you're avoiding that, you're really biting off your nose to spite your face in the context of what are your rights as a parent under the IDEA, because you are not given an equal seat at the table in terms of how decisions are made by the IEP team. What the regulations give you is this right to appeal. However, clear, respectful, and professional communication, keeping good records, keeping everything in writing are your best, and engaging in the process are your best strategies for solving problems formally or informally. Or if you have to go to a formal process, having the evidence that you need to potentially have a better outcome. So I think that's the end of the FAQ questions that we had. But I understand there may be more.
Okay, so just reminding folks that we have our education helpline here at VFN. So you should definitely call us if you have, challenges that we can help you with. So thank you, Cammie, for sharing this presentation. Before we get to the questions, I am going to take a short pause to ask folks to complete the evaluation for this workshop. We have the link in the chat, so I'm just going to give you about half a minute and would really appreciate it if folks would open up the link and do the survey. Okay, thank you. So, Cammie, what I'll do is I'll pick up some of the questions that were asked. There are too many, I think, to go through all of them.
Okay.
So, um, is a formal dispute process the only scenario which lends itself to a stay put? So, for example, if a disagreement about the results of a 3-year assessment, which leads to an
Yeah.
approve, yeah. So, is that the only way that can be
Stay
invoked?
put is, yes, stay put is only available through filing for due process.
Okay. This is one we've heard a lot about. How can parents address the staffing shortages that are being used as a reason to not be able to provide specialized services or programming to their children?
There is no perfect answer to that question. I wish I had one. Um, Continuing to meet regularly with your child's IEP team, ensuring that records are kept that reflect the services that your child is not receiving, potentially filing an administrative complaint. I think something that I have had parents be successful in is coming up with some creative strategies for what are the services my child's not getting because of the staffing shortage and what could meet that need, and going to mediation and mediating for kind of an outside service that the IEP process might restrict access to, that through mediation the school can agree to provide as a comp service um, for their failure to provide whatever the service in the IEP is. Um, if you, I know the Agency of Education has also encouraged parents to reach out and be letting them know when services are not being provided due to staffing shortages. But ultimately, there's no perfect answer. And I think the best thing you can do is to continue to work with your child's IEP team to make sure there's good documentation about what's been missed, to be thoughtful and have conversations about what could be present alternatives, because we know that compensatory services are not always as effective as missing services and then getting more to make it up. And I think from really the parents who I've worked with who've been the most successful are the ones that are really willing to be creative thinkers in saying, I want you to agree at mediation to pay for me to fund a tutor. Or I found this social skills group for my kid to attend and I want you to pay for it. Um, those are the parents who I've worked with who have been most successful in ameliorating the barriers to services.
Thank you. Do parents have the ability to bring a recorder with them so they can record an IEP team meeting?
Vermont is a single party recording state. What that means is that if you are a participant in a meeting and you decide to record that meeting, you do not have to let the others participating in that meeting know that you were recording that meeting. It has been my experience, especially in the digital age, that districts are very willing to agree to record meetings and make that recording part of a child's educational record.
Okay, what should one do after an IEP request has been delayed for several months and the student has suffered? How do you proceed with considering an alternative placement?
Hmm. Well, I would ask, what does delayed for several months mean? I would ask or think about, was the specific request that was made clear? But ultimately, if you've made a clear request, there has been no IEP meeting and there's been no response to the request, um, you potentially should consider filing an admin complaint for, failure to hold the IEP meeting, failure to engage in that process. But in terms of pursuing an alternative placement, um, if the district doesn't agree that your child needs an alternative placement and you believe that they do, then you may have to consider due process to try to prove why an alternative placement is appropriate for your child. Because the admin complaint process is going to get an analysis of the present facts, but they don't have the tools to make a recommendation about potential placement.
Okay, then a couple of questions about Section 504.
Okay.
I guess what are the avenues of complaint when it is about the Section 504?
So there is filing a complaint with OCR, the Office of Civil Rights, through the U.S. Department of Education. However, OCR is on shaky ground right now. And in the world of the new administration. And OCR has been chronically understaffed for years, and complaints are taking a very long time. So that is an option, but if you are considering pursuing that option, you should know that you're unlikely to get a fast resolution. Due process is available for issues of 504, issues or allegations of violations of 504, but the admin complaint process is not. So if you have an alleged 504 violation that can't be resolved through team meetings and isn't being resolved through mediation, your options are OCR or due process.
Can any LEA from the district be part of my child's IEP decisions, or do they have to be listed on the IEP? So I think that question might be asking the role of the LEA in decision making.
So, without pulling out the rule and quoting it, the LEA who is assigned as the LEA at an IEP team has to have knowledge of what resources are available in the district that could potentially be provided to a child. I would say no if someone's name is listed, but there is another administrator or special education case manager who is acting in that capacity as the LEA. You're not entitled to a particular person. What you are entitled to is someone at that meeting who can make decisions on behalf of the district.
And that's why it's important to make sure that the school knows what you are asking for so they can get the correct LEA to the table.
Agreed.
If a parent gets a written IEP, does not agree with one part of it, the rest of it is okay, what steps and time frame should they take to dispute that part? And in that timing, what is the process for ensuring that services in the current IEP are maintained while there is a dispute?
I think if you get an IEP and you disagree with a part or portion of it, you should first ask for a meeting to discuss that part or portion of the IEP. If there is not agreement after that, I guess my answer depends on whether it's an initial IEP and we're talking about consent for services, or if a child has been found eligible, there is consent for services, and it's really a matter of a dispute about the substance of the IEP or not providing a service. So if a child has been found eligible and it's a question of, I disagree with this essential portion of this initial IEP and I don't want this to go into place, but my child's not going to get any services if I don't sign consent, I would generally advise someone to sign consent. And if there's really a specific portion that you are in complete disagreement with, you could note in your consent that you're not consenting to X service. That way you're protecting your child's rights to receive the other services that you do agree are appropriate. After that, I think trying to resolve that through an IEP team meeting. If you continue to be at an impasse and you think that that is a denial of FAPE or another violation of the IDEA, you could certainly file an administrative complaint, try to resolve it at mediation, or have the Agency of Education opine on whether that is an appropriate thing to be in the IEP. And depending on how fundamental the thing that you disagree with is, you might consider whether you feel like due process is appropriate, and be willing to just agree to the exclusion of that or the introduction of other services to address that need in a different way.
Thanks, Cammie. Do you need to provide all the evidence for the admin complaint while filing the claim, or do you just cite the rule violations in that complaint?
You have to allege a violation. You also have to describe the facts that you are aware of that support that allegation. You do not have to provide the Agency of Education your child's entire educational record. That's part of the investigation process, is them getting the educational record from the school district. However, I have certainly had cases and experiences where, something was a really blatant violation, and I found it helpful to include that with an administrative complaint. But it's certainly not necessary.
Okay. If the school refuses mediation and your child has no plan in place, what option does a parent have?
If a child has no plan in place, that would lead me to believe that there was either a finding that that child was not eligible or a refusal to evaluate, in which case I would probably consider starting with an administrative complaint process, and alleging that there was a violation of the requirement to child find, or what the context of that decision not to find that child eligible is. But that's a tricky one to ask, or excuse me, that's a tricky one to answer, because if a child is eligible for special education related services, there's usually some sort of plan in place. You may not find it good enough, or you may not like it, or it may not be the best plan. But commonly, if a child is found eligible and consent's been signed, there are services and there is a plan, even if it's not a good one.
Can students attend their own IEP meetings so they can be on board with their accommodations and know their rights as a student and a person with a disability in the education system?
Yes, students should be invited to IEP team meetings. They're not always required members. Once they turn 18 and acquire their own parental rights, they become a required team member. But I would absolutely encourage that your child attend their own IEP meetings and develop that self-advocacy skill.
Okay, if a parent is a parent signing an IEP revision required if a school does not ask for a signature? Does the revision automatically go into effect after a certain number of days?
I think this is a really good question, not necessarily because of the question itself, but because it begs something that I see a lot, and that is parents calling me and saying, "But I didn't sign the IEP." And signing the IEP in Vermont has no legal effect. Once you've signed consent for services, you have consented to services. And when an IEP is revised, signing that revision is not is not the equivalent of consenting to that revision. So I would encourage a parent who disagrees with something in their child's IEP that's been recently revised to fill out that parent feedback form, to submit that parent feedback form, to make sure that that parent feedback form is being included with their child's IEP in their educational record, and to be requesting a follow-up meeting specifically versus leaving it to the school district to choose whether they schedule a follow-up meeting.
Okay, Cammie, I think just one last question. Since we're bumping up on time, can a parent file an administrative complaint regarding an evaluation if their child is on a Section 504?
If the allegation is that there was a failure to find that child eligible for special education related services under the IDEA.
Okay,
However,
okay.
if it's a straightforward 504 issue, the answer is no.
Okay, thank you, Cammie. I think I was able to get to the questions that were specifically about dispute resolution. There were some other questions, but they were maybe more about special education process in general. So just remember that VFN has our helpline, and certainly you can call DLP directly if you would like some advice there. So for everyone, again, this is a great workshop. We really appreciate your taking the extra time to stay on to answer all of these questions. So for everyone else, we have many more interesting workshops coming up, and you can find out details about those on the homepage of our website. So remember that we are here to help at VFN. Contact us by phone, by email. So thank you again, everyone, and have a great day.
Thank you so much, Karen.